Welcome back, everyone. It's just shortly after 1 o'clock, and while you're getting settled, I'll just begin our introduction to the next session. Our next session is titled Interpretation and Accommodation. And our speakers, and this time I think I'll introduce them in the order that they'll speak. Our first speaker this afternoon will be John Borrows, who's a longtime Osgoode friend and is currently on the faculty at the University of Minnesota. And the paper he's written for this symposium is titled Aboriginal and Treaty Rights and Violence Against Women. It's a highly original paper, so we're looking forward to John's remarks in the discussion. And John will be followed by Colleen Sheppard, who's on the faculty at McGill Law School. And Colleen's paper this afternoon is titled Inclusion, Voice, and Process-Based Constitutionalism. And once having heard those presentations, and we'll stick to the timelines as best we can, as we did this morning, after those presentations, our colleague Sonia has agreed to provide an interpretation and make some remarks. And so we'll follow the same format as we did this morning. We'll run through the presentations, we'll open the floor up, and then we'll see where it goes from there. So without further ado, John, please go ahead.
Great. As others, I'd like to express my appreciation for the invitation to be here. And I'm grateful for being in such wonderful company. It's coming back to familiar grounds to be here. I did my doctorate here and I taught here in the early 90s, and seeing the changes is also very inspiring to me. This paper that I've written today, Aboriginal and Treaty Rights and Violence Against Women, comes from two sources. One, the opportunities that I've had to be able to teach in the United States the last few years and get more fully into US constitutional law and think about that field from a comparative perspective. But secondly, I went home this summer and had this paper due as I was at home. And I was wondering what emphasis I might give. And as I was there, I was visiting with my Aunt Vera. She's an elder on the Cape Croker Indian Reserve, which is about 3 hours north of here on the shores of Georgian Bay on the Bruce Peninsula. And as we were visiting there, we had gone to powwow the few days before, and there were lots of people in town as a result of that. And so we were meeting some of the folks from far away. And as that was occurring, the subject turned to the politics that's happening within the community. And one of the decisions that had been made by the Band Council was to shut down the Women's Crisis Shelter. And I was very surprised by that, because ever since I've been around Cape Croker, that's been one of the gems in our community, where we hold out this place of safety and trying to work towards the elimination of violence against women. And so to know that this was possibly on the agenda disturbed me. And it made me think about what it was in some of the incentives of the Band Council to think that this was appropriate to be able to shut down the shelter. Started me on this path of wondering about Section 35 and how it's incentivizing communities in relationship to choices where they're spending, I think, about $40,000 a month on lawyers in good work that's being done in relationship to Aboriginal title and Aboriginal resource use on the peninsula. My great-great-grandfather signed a treaty dealing with 1.5 million acres of land in Ontario, and those treaty terms have not been fulfilled. And so it's important to be able to bring that to the attention of the courts and work through the challenge in that way. But as that's going on, right, we're now in huge deficit in the community, such that you would take this resource, which is incredibly important, and regard this as something that you could shut down. And so as I started connecting the dots between what's happening constitutionally and what's happening locally in the community, I recognized that there's a couple of obstacles, structural obstacles, that have to do with constitutional agency. Who has agency in constitutional terms in Canada, particularly when you're talking about Indigenous peoples. And I thought that these structural obstacles were of two types. One, there was something in society at a conceptual level that had made a judgment that Indigenous peoples cannot deal with violence against women. And secondly, when I started thinking about how those societal structures, conceptions, might get interpreted in the jurisprudence, I recognized that we have an interpretive, something at the doctrinal level that constrains constitutional agency on the part of Indigenous peoples. So just to take both of those two challenges, those two hurdles, what is it at the conceptual level? Why is it that we can't imagine that Indigenous peoples would deal with violence against women? And one is because Aboriginal communities, like many other communities, are male-dominated in very disturbing ways, and that there is an excessive degree of violence within these communities, and that is transported into these communities by those from other places, and then as women and others flee the community, they encounter violence in the cities and towns that they settle within. And so there's something right about wondering whether or not violence can be dealt with when you're in a community that faces violence, and in an exceptionally intense way. And so I want to acknowledge that is building on something that is important and must never be forgotten and never be undermined, that when we're dealing with violence against women, we have to recognize that the context that you're dealing within is itself so fraught. And so that's part of thinking about it at the conceptual level. But then when I peel back further there, I have to also recognize that not all communities and all places within the communities are violent places. There's a lot of happy, good, healthy relationships within Indigenous communities and between Indigenous peoples and other peoples that should be a part of this story. And another part of the story is that even in situations of violence, that you find communities taking steps in very positive ways to be able to address this issue. So two responses. One, not to paint everyone with the same brush, that Indigenous communities are uniformly just places of, and I'm going to be blunt, savagery. Secondly, though, in these communities, even if you're in these circumstances of deep trouble, people can address those troubles. In fact, sometimes you're better equipped to address these problems, particularly amongst the women who know what works and what doesn't work. I borrow this insight from Hannah Askew, who's living with us as we were doing this research this summer in an Indigenous law degree, that many of these women, because of their experiences, actually have great insight as to how you would go forward in dealing with this issue. So that's the conceptual level. And then the three parts that I then look at in relationship to trying to push back on that societal conception are, one, well, Canada has not done a great job of being able to address this. Right? If you look at both the federal and the provincial government, there's a couple of commission of inquiry dealing with violence against women in terms of murdered and missing women. But they're framed so narrowly in terms of what their reference terms are, and then any action that's taken is just so weak in getting at the structural elements of what's the cause and why it is that we continue to have this reproduction. So to say that Aboriginal peoples wouldn't do a good job if they would get it, might assume, well, Canada's doing a good job or Ontario's doing a good job. But that's not the case. So we have to take that standard of judgment off the table, I think. Secondly, we also have to remember that if we were going to talk about this in doctrinal terms, if we were dealing with, say, jurisdiction in communities to deal with violence against women, that jurisdiction would always have to interact with Section 35(4) of the Constitution Act, which says Aboriginal and treaty rights are guaranteed equally to male and female persons. So if a community, through male-dominated politics, takes steps that would further undermine the place of women within the communities, there is at least this toehold to be able to argue back in relationship to, you can't do that. that would be constitutionally invalid to be able to take an action that would put, so by actually putting this on the table, then I think what you start to do is you create incentives in the community to be able to look at violence against women differently. So every time you make an Aboriginal and treaty rights argument, you're also making an argument in relationship to gender, right? They are joined by virtue of Section 35(4), such that I would like one day for our community to see that when you close down the women's crisis shelter, that's as much an issue of Aboriginal and treaty rights as thinking about the fish and the land base that are around us. And that would come together in that way. So that's another addressing at a conceptual level. The third is the experiences that I'm drawing upon teaching in the United States now for the past little while, where there are internal incentives on the part of tribes to redraft their legislation in relationship to violence against women. And there's still a lot of room and work to do there, but it's substantial. In my paper, there's many footnotes that talk about the different ways that violence against women is becoming central in tribal politics. And for tribal leaders to ignore that is to recognize that they won't be voted in the next set of elections. And so I'm thinking about incentivizing this. And then there's external pressures as well. The federal government recognizes that they have to work with tribes to deal with there's this new act, the Save Native Women Act, which is to stop violence against Native Women Act, where the federal government would recognize that tribal peoples have jurisdiction over non-Indians who would be on the reserve and through their statutes and their tribal courts have ways to deal with that violence that would occur within the community. That's conceptual, societal. You can see how it's interwoven with doctrine. The second level has to do with the interpretive obstacles. And quite frankly, if Indigenous peoples were to make an argument to assert jurisdiction in relationship to violence against women, they would have to show that this was integral, this jurisdiction, to their distinctive culture prior to the arrival of Europeans. So what would that evidence look like? You would be bringing forward the abuse that was a part of Aboriginal communities before Europeans got here. You'd have to show a continuity of that abuse from the point of contact to today, and you would have to show that that makes the society what it was or what it is. That just cannot be a standard. And then in the treaty context, you would have to say it was in the contemplation of the parties at the time of the treaties that Aboriginal peoples would have jurisdiction in relation. Of course, when they signed treaties, they weren't creating for all time documents in relationship to these ideas. What does this boil down to? What's doctrinally, structurally wrong with Section 35(1) is it is originalism, right? That is, what was the intent at the time the treaty was signed? What was the public meaning at the time of contact or the assertion of sovereignty? That you cannot claim any other rights unless they're rooted to that moment. Of course, history is very important. You have to tie many things in Aboriginal communities to history. But to limit development in relationship to history is what originalism does. And that's what's happening in the Canadian constitutional context. We pride ourselves in talking about a living tree, right? This is an amazing innovation that we've fostered in this country, and yet it is not applied without discrimination. It's applied discrimination. In other words, Aboriginal peoples don't get to participate in living tree jurisprudence. Right? That seems like a deep flaw in our constitutional structure, to allow the entire society to be able to, and just to read some of the cases, well, I won't read the case. You know the living tree notion. To allow an entire society to take that view, while Indigenous peoples have to be tied to what was integral to their culture before people got here, or what was in the intent of the mind of the parties at the time of the treaty, will not allow us the constitutional agency to deal with the mess that we're in. And it's not being dealt with by the Canadian government and the provincial government, and we're exporting and importing violence back and forth across the reservation boundary line. And so my contribution to this panel is to think about who has constitutional agency, what are the structures that prevent the engagement of, in this case, Indigenous peoples from being able to participate in its further, that is the Constitution's further development. Thank you.
Thanks, John. I feel so mean making people comply with the time limits because we would have wanted to hear more, but we will get back to you, John, and I'll turn it over now to Colleen and invite Colleen to take the mic.
Okay, thank you. Thank you to Jamie and to Ben and to the Osgoode Hall Law Journal. Can you hear me at the back? Okay. My paper, which is Inclusion, Voice, and Process-Based Constitutionalism, explores what I call this growing emphasis, or what I've observed, a growing emphasis on process issues in the elaboration of constitutional rights and freedoms. I want to say perhaps a caveat at the outset. I don't think that one can ever actually carve off process from substance, and the two are critically intertwined. And indeed, the work and that's partly why I put inclusion, voice, and process-based to try and get some terms which resonate more with ideas of justice and substantive justice. And indeed, Lawrence Sawson's work on procedural justice, I think, also resonates with this idea. And some of the work that I've some of my interest in issues relating to process stem as well from work that I did on equality rights, trying to think about the idea of substantive equality in ways which would speak to structures and the reproduction of inequality in various institutional and political contexts. And I tried to develop an idea of inclusive equality, which would embrace both substantive equality, but also be attentive to process issues which result in the recreation of inequalities. In this paper, I explore some issues relating to process and practice in some other domains, and I highlight, and very briefly, and the paper is still very much of a draft, ideas around the duty to negotiate, the duty to consult, duties or recognition of the importance of participation in democratic governance, and even the duty to accommodate, which resonates with some of the ideas which have been explored earlier today. Now, beyond what the courts and what lawyers are arguing, I think that these ideas have been picked up by political theorists, by politicians, even within social movements as well, where increasingly there is attentiveness to ideas around democratic accountability, accommodation of minorities, dialogic democracy, participatory democracy, inclusive citizenship, critical multiculturalism. And I think as constitutional scholars, it's important to canvass both the promise and the perils of this interpretive shift, and to think about how such a shift may be shaped in the future to ensure that it reinforces rather than undermines the enhanced and effective protection of constitutional rights and freedoms. I think there's a call towards developing our critical thinking and scholarship around issues of substance and process. And I think, in fact, in reading John's paper, I think there are some important connections between his contention that we should take self-governance and democracy seriously within Indigenous communities and the idea of constitutional agency. And I think there's an overlap between our papers in that regard. So more in terms of to outline some of the shifts or contours of the shift toward process-based values, I think we can see it in the paper begins by looking at the procedural turn outside of the constitutional domain, going back to scholarship by Gunther Tugner, for example, on reflexive law or on even legal pluralism, scholars such as Sally Engle-Mary, who examine law operating in multiple sites and within and between semi-autonomous social subsystems. Tubner, for example, in his scholarship from the early 1980s, outlined policies of proceduralization whereby the legal system concerns itself with providing the structural premises for self-regulation within other social subsystems. And Sally Engle-Mary's insights clarified how law operates within multiple and overlapping institutional and social contexts. And I've drawn extensively in my work on equality on Susan Sturm's work on structural discrimination analyzing how legal norms play a role of opening spaces for ongoing engagement with current practice in relation to aspirations that have been identified as being of public significance. And I think that resonates with Abigail's idea about creating democratic spaces through understandings of law. The work of numerous political theorists from Iris Marion Young and in the Canadian constitutional domain, Simone Chambers and James Tully, also highlights the importance of process issues, democracy, inclusion, and diversity, accommodation, negotiation, etc. So I guess the question I pose in the paper is, to what extent is this procedural turn apparent in Canadian constitutional jurisprudence? And it's carving off a subsection. That is, I'm looking at what judges have had to say about, to what extent have judges recognized, or to what extent do their judgments resonate with this procedural turn? And I think perhaps one of the most visible starting point for thinking about this issue is the secession reference case, where we see the court identifying these 4 fundamental principles of Canadian constitutionalism, which include democracy and minority rights, as well as federalism and the rule of law. In the charter context, the context which I explore in the paper include a range of examples. One, the cases around linguistic minority rights, and in particular, minority education rights. And there, I find it's interesting that in the early cases, the Mahe case and the Arsenault Cameron case, you see the court explicitly recognizing minority education rights as encompassing a right to management and control by the minority community of minority education institutions. And that idea, it speaks to a process concern, and the court is quite explicit in emphasizing that the majority does not know what the specific needs of a community are, and indeed, we need to empower those communities as a dimension of our linguistic minority education initiatives. Another area where, and I guess perhaps as I go along, I'll just highlight I think the problem is that every time the court recognizes these process-type rights, there's also risks associated with it. And in the minority linguistic education context, I think there is a risk that, in fact, one has to contextualize the situation of Francophone minority communities outside of Quebec as one where there is a significant risk of assimilation, even if the court gives very progressive, highly progressive and innovative constitutional interpretations. So how does this rhetoric around management and control and a robust interpretation of linguistic minority rights resonate with a larger systemic, historic, and political context where there's a real risk of assimilation? Another example I explore in the paper is the duty to consult, which where the court really spoke very explicitly about this in the Haida Nation case back in 2004, where we see, prior to the resolution of the Aboriginal title claim, the court concluded that the government had to consult with Aboriginal peoples where there was a risk that logging activities would significantly undermine their community and their concerns as a nation. And that, again, I think is very positive. And Lauren Dawson's work, again, has dealt with the duty to consult from and the sort of promise and the perils of that shift. The legal duty to consult, the duty to accommodate, the duty to negotiate were all folded in there, but the duty to consult, I think, is connected most closely with the Haida Nation case. But again, while that I think is positive, and I was just speaking to John about what has been the outcome of that in terms of what's happened on the ground, and there have been some significant positive process-based initiatives that allow for greater participation and voice and the airing and control by the Haida Nation as to what's happening in their territory. One also has to ask, whenever the court provides a duty to consult, what is meaningful consultation? Who's being consulted within the community? Is the duty to consult an excuse for unacceptable delay in the resolution of the substantive issues? And more generally, although I don't think it's relevant in the Haida case, is there the who's being consulted, there's a risk of partial consultation, or to pick up on Abigail's point, that you'll actually turn to the more powerful elites within a community as representatives of that community, and the voices of those who may not be as powerful will be forgotten or put aside. Just another a couple examples. The other two I deal with is freedom of association jurisprudence, and there we see the court talking explicitly about, and in the health services case, a very significant case where collective bargaining is recognized as a part of the duty to negotiate, and collective bargaining is recognized as a component of freedom of association. The court, in doing so, highlights the value of worker participation in governance, workplace governance. Again, the values of democracy come through. And in the Fraser case, the more recent 2011 case dealing with agricultural workers in Ontario, again, we have the litigation about what is the duty, what does the collective bargaining entail? Does the legislation have to speak explicitly about imposing a duty on employers to negotiate in good faith? But all of those issues around the duty, collective bargaining and the duty to negotiate raise concerns about bargaining power. And even if you had the most elaborate process-based guarantees for agricultural workers, to what extent would the substantive inequalities in power in terms of agricultural workers versus their employers continue to dictate the outcome? And therefore, again, the language, particularly by Justice Abella, for example, in the Fraser case, where she finds that the legislation was inadequate and it has to provide a more robust obligation on employers, and the legislation should impose a duty to bargain in good faith, parallel to what's provided in other collective bargaining legislation. Even there, does that go far enough in protecting substantive rights of vulnerable workers? And the duty to accommodate, I think I'll just jump over that but you see that with respect to religious minorities, I'll mention religious minorities. The Multani case is an important case where we see the duty to accommodate being argued. And now the duty to accommodate, I think one can critique it for perhaps being a mechanism which allows for some special treatment to a group which allows them to fit in uncomfortably into an institutional or dominant institutional status quo. But on the other hand, I think there's a way in which the duty to accommodate, and in the Multani context in particular, there's a concern with promoting institutional accommodations and dialogue and discussion across differences to sort out how, in fact, a young Sikh student could continue to attend a public French school in Quebec. And the language and religion and race issues are very interconnected, and how school authorities and what kinds of processes should be endorsed to encourage that kind of accommodation. So I guess just to finish up, I think that I'm very much interested in your comments and ideas, because I feel that I haven't quite worked out the full implications of my paper. But on the one hand, I think that the recognizing process issues is important, and it holds significant promise for reinforcing what John called constitutional agency, and for reinforcing democracy, participation, the engagement equitably of all citizens in governance. It goes beyond, it also takes the focus off judges as the final adjudicators or decision makers about the kinds of arrangements that we in society think are most equitable and fair. But I think there are also significant risks, and I guess it's sort of, I was thinking of that when Abigail was talking about identity politics. It's good, but there are risks, and how do you navigate or mediate between the two? That there's a risk that, I think there's a risk that process rights will be accorded over substantive rights or instead of substantive rights. and that the rhetoric of those process rights becomes a source of legitimation for the denial of substantive rights. And so that's a huge issue. And not that but I do wonder whether the judges are going to come up with the best sort of recipe for what those substantive rights should really look like. There may be a risk in some instances that the process rights delegate to other institutional contexts important decision-making, and that sort of resonates with the weak form constitutionalism, delegates to other decision-makers the rights to make choices about how things should be done, but those other contexts may be contexts where there is inequitable power and privilege. There may be a risk of assimilation as a precondition to participation. The problems around consultation and what does consultation mean, and the risk of an unequal structure of representation within the consultation process, or no real shifts in power. And again, I think all of these problems are rendered more complex by the fact that there's a constitutional rhetoric that legitimates. It sounds very good on paper: dialogic democracy, participation, consultations, duty to negotiate, and yet one has to line that up with what the actual outcomes are. So as I said, I suppose the conclusion of the paper is that it's useful to recognize and even to celebrate a procedural turn, but it's important to be vigilant in ensuring that its promise outweighs its perils. Thank you.
Thank you very much, Colleen. We're really looking forward to the remarks of our colleague Sonia Lawrence. So over to you, Sonia, and once we've heard from Sonia, we'll open the floor up.
Okay, thanks so much to everyone involved in organizing and participating in the day. It has been really stimulating, and Ben and Jamie have gone and set me loose on these colleagues and their work. So let me just quickly offer my thoughts on each in turn, and we'll get as soon as possible to our discussion. So I'm going to start with John's paper, and I think if you're familiar with his work, this paper is both, it's characteristic in that it's both bold and modest, it's ambitious and it's careful. And I think one of the first things that struck me is how courageous it is in a way to enter this conversation, because it's one that engages with kind of devastating and ongoing trauma where the stakes are extremely high, not only in the long term, but in the short. So the statistics that John cites about the violent reality of the lives of many Indigenous women in this country, but not all, they demand attention, but the attention that they normally or usually receive is attention that comes without the resources and authority that John notes are going to be a requirement of material change. So John's paper opens with the demand that the Constitution address and improve this situation, and that's a really broad demand. So let me make one comment about what John's doing in the paper and leave the rest to our discussion. The article, I think, must make two different claims in order to succeed. The first is about how we use the Constitution to do justice about jurisdiction. And then the second one is about doing justice within jurisdictions. And my thoughts are really focused on the second of these two things, but also maybe about the nature of the relationship between the two. So just to go back to the first briefly to explain, the effort to use the Constitution to do justice about jurisdiction is the claim that the Constitution should have something to say about violence against Aboriginal women, and the fact that that it does have something to say about it, as Section 35 constitutionally should grant that jurisdiction over violence to First Nation women. And I think this particular part of the claim is amply supported by John's own work and the work of many others. It's a difficult claim to make through Section 35 doctrine as it's currently being developed, but it's not particularly difficult to make more broadly as an aspect of self-governance. And I think the devil will be in the details of this one, of course, but let's set aside those issues for now, because I think the details of the jurisdiction to be exercised aren't, and I think don't need to be, part of this paper, although they will matter a great deal as the project moves forward. So the second claim is the one I want to focus on, the claim that within Aboriginal jurisdiction, justice will be done, or maybe justice will be more possible. And the nature of the connection between these two kinds of claims, justice about jurisdiction and then justice within jurisdictions, is one that's been confronted before. And the example that came to my mind, I'm not sure if you'll agree with this analogy, is just thinking a little bit about Bruce Ryder's work on the division of powers struggle over provincial anti-Asian legislation in early British Columbia, or work that considers the line of implied Bill of Rights cases in pre-charter Canada. So John opens by calling the law on the carpet. Why is there no Section 35 jurisprudence on violence against Indigenous women despite the material facts? And I think the challenge that he set for himself is then he has to argue that the transfer of responsibility is going to lead to that kind of material change. And then the question I'm asking is, what kind of arguments get deployed to say that the change will lead, that this change will happen? So I think in the piece you see claims about cultural responsiveness, we see claims about post-colonial anti-racist activity. We also see some arguments that I wondered, because without using the term, I thought they were suggestive of arguments based around principles of subsidiarity. And the challenge here for me is that when discrimination or oppression within a community is at issue, local level adjudication is often a vehicle for that oppression. So I think John offers some accounts of how the local level might be politically influenced by both internal, local, and larger external pressures, and local traditions or certain strands of local traditions. But I wonder if engaging with more abstract claims about how local adjudication has a harder time dealing with discrimination at local levels might be one way to kind of think more about the claims that John's making. Like, what do we do when one rights principle seems to require local level adjudication and another rights principle is potentially jeopardized by local level adjudication? Just to spin this out a little bit more, in the US context, some of you might have read the article in Harper, it was in 2011 in Harper's, that looked at the underreporting of serious violence against women on tribal land in the US. And the author visited a number of reservations, and in one of the places she visited, a Sioux woman spoke bitterly about the tribe's ability or inability to combat violence with the authority and resources, and that's the phrase from John's piece, the authority and resources it actually had, and she cursed the laws of the tribe as tiny little laws. That's the title of the article, and I really urge you to read it. It's a very interesting one. So in Canada, we've been having this conversation, for, as John says, about 20 years. And the article that started it for me was Teresa Nahani's Dancing with a Gorilla article and other articles from about 20 years ago. And I refer to that article because it was written right after the federal court ruled in the NWAC case, which is discussed actually in both papers, and before the Supreme Court decision was handed down. So Nahani appeared to have been writing in that brief period of time where NWAC had won their case. And she wrote, without equal participation, consultation, and funding, Aboriginal women's organizations today would reject the establishment of an Aboriginal parallel justice system. So, as John recognizes, 20 years have not stopped these critiques. And I do think that the article is incredibly careful in describing the kind of risks and concerns. I'm not worried that this is something the paper is not addressing. But I did want to look a little bit about the way the article posits the possibility that Section 35(4) can backstop against gender inequities in the exercise of First Nations jurisdiction. And I think there are some real reasons to be concerned about that possibility, not the least of which is the reality that the other gender protection section, Section 15, has been used more successfully by male claimants than female claimants. So Section 35 might be that backstop, it might not. And the other reason, of course, is the possibility that the exercise of inherent jurisdiction, which you turn to at the end of the paper, might not be constrained by Section 35 at all. So, again, the paper is really careful about these things. It's respectful of the distance between an argument about jurisdiction and the rights retaining living bodies of Indigenous women, the subjects of this jurisdictional argument. And I think that respect comes from the attention to the contributions that Indigenous women have made and will continue to make, shaping the exercise of First Nations jurisdiction. In other words, this is not just about these women. This is an argument about changing the women from the subjects of jurisdiction into the holders of the jurisdiction, and I think that's a really powerfully symbolic move. But, much like what Bruce Ryder found when he was looking at the anti-Asian legislation, the moral high ground in jurisdictional disputes is really difficult to discern because there are two questions being asked, right? Where is the justice in assigning jurisdiction, and then where is the justice in doing jurisdiction? In the anti-Asian cases, you might remember provincial racist anti-immigrant legislation was deemed ultra-virus, and then brutal and racist federal migrant labor schemes were enabled through that jurisdictional change, right? So jurisdictional transfers between federal and provincial governments to First Nations could be even more fraught because, and I return to this phrase again, because of the limited transfer of authority and resources. So I think this is another piece of detail which will matter deeply and which might ultimately be as important as jurisdiction and its exercise in achieving any material change. So there's a lot more in this paper to address, and John's going to get an impertinent email from me in which I ask whether his own work actually suggests quite a different vision of what a Section 35 claim could look like, and whether the originalism claim overreaches a little. But I'll leave those for now, because I do think that John's paper provokes some really fundamental questions about the meaning of rights, and thinking about rights interpretation versus resource allocation as key factors in material change. And I think Colleen's paper is looking at the same thing, right? What do rights actually provide? So with respect to Colleen's work, I think the question that I wanted to raise is one that takes a little quarter turn away from assessing the merits of the procedural approach and asks instead about how we landed here. That is, why are courts apparently increasingly resolving constitutional claims with procedural rather than substantive rights? So if it's true that judges increasingly prefer procedural resolutions, on what theory, articulated or not, are they doing that? Now, I'll just try to explain that a little bit. So I think Colleen's article assesses the implications more than the impetus. And although those are clearly related, so the implications of the procedural turn and not the impetus of it, and I think those are not the same thing. From the perspective of the court, that is the court, not the litigants, is the procedural turn actually a veiled route to conservative outcome? Is it a legitimacy protecting move? Is it inherent? Do the cases represent judges expressing, as you said, expressing hope about dialogic democracy, or just illustrating their belief that courts lack institutional capacity to decide such cases? So that's a long list of questions, but the issue I'm raising, I think, may relate to kind of standard ideas like Bickle's notion of passive virtues and constitutional adjudication. In the Canadian context, the place that I'm taking it back to is my dean's work, who's applied some of these questions to the work of the McLaughlin Court in the broader zone of procedural justice, so as you said, outside just the charter zone. And his question there was asking, when is a process-based resolution a prudent choice, rather than asking when is a process-based resolution a just choice. And so Sawson argues that the procedural turn characterizes the second generation of charter jurisprudence, and he suggests two possibilities. Either the turn might be a sign of weakening of the court's commitment to the Constitution as a mechanism to constrain government action, or it might just signal a maturing of that commitment and an evolution of the court's role as a catalyst of compromise. So I think that Colleen's work in her paper offers an opportunity and perhaps calls for an effort to answer that question. What does the court actually think it's doing? The theory on which the court turns to procedural guarantees, I think, differs fairly profoundly between the various examples that Colleen provides in her paper. For instance, in the Aboriginal context, competing possibilities might include a belief that government-to-government negotiation is constitutionally appropriate in those circumstances, a belief that if the disputes aren't removed from the court system, they'll overwhelm the court system, that the court lacks expertise, maybe a concern that the length of time is dysfunctional, the length of time these disputes take in the courts is dysfunctional for the litigants. In contrast, I think your article illustrates that the language dispute cases have quite different reasons that there might be a procedural turn. And in those cases, I think the fact that the procedural rights are tacked on to substantive rights granted in the same breath, I think might be significant. Okay, and then another possibility, although I do think that the reasonable accommodation jurisprudence is so muddied right now that it's not the most stable base for us to do theorizing, but I think that the procedural justice that you're talking about in this paper is very much about groups. Because when I started reading the paper, I think I had a different thought about what procedural justice refers to. So procedural justice in the criminal law area is a very different kind of thing, and it's not integrated into this discussion. And rights in that context, when procedural, don't have any obvious dialogic component, and they typically involve an individual claimant. And so I had thought, well, maybe there's a place to go in thinking about some of the writing in the US about what the consequences of the Warren courts turn to procedural justice in criminal law cases have been over the past, say, 40 years of US criminal law developments. But it may be, in fact, that your response will just be to define the non-dialogic procedural interpretations out of the scope of the paper. So I think that might be where I am now. So let me just wrap up by pointing to the way in which these papers really do intersect. And that is, each points to the ways in which pushing rights realization into governance structures requires attention to precisely what happens during those moments of consultation or participation. And without this attention, the danger or the likelihood is that all we're going to see is the replication of existing structures of power and control. So thanks again to the organizers, and miigwech to John, and thank you to Colleen for these two really interesting papers that prompt us to think about how rights are engaged in the real lives and aspirations of Canadians.
Thank you very much, Sonia, and thanks to all three speakers. I'm going to put myself at the bottom of the speakers list because I saw a hand shoot up immediately, and I think Jenny is the first to put her hand up, and then Mark Tushnet. And sorry, what? Oh, yes, thank you, Ben. We usually do start by asking John and Colleen whether they want to say anything right now about Sonia's remarks, and I'll just deliver the microphone in the meantime.
In relation to my paper, I agree with most everything you've said. That is the kind of attention that's needed in thinking about jurisdiction. In relationship to Colleen's paper, I want to talk about one of the perils, which is, remember, the duty to consult is a search to cut down the right. It assumes there will be some kind of reduction as a result. So you're consulting with people in relationship to infringement. So if you're dealing with, say, freedom of religion or association or some kind of liberty or security interest, this is someone coming to you and saying, how can I take away some of that liberty, religion, equality? In other words, this is my land. How can I take away that land or reduce its scope? So that I think there's a lot of promise that we can talk about in this field, but it also has to be piggyback on to where it comes in the analysis in relationship to the right.
Thank you, Sonia, for really wonderful comments. It's useful to be in a forum like this and hear and get the feedback. And so I just wanted to thank you for that. And also, I just had one comment about John's paper in terms of the frozen rights idea, because I think that can't you just go one level higher? Instead of saying that we have to talk about violence against Aboriginal women, you can say that historically Aboriginal governance included mechanisms for dealing with criminal justice issues in their communities, rather than putting it onto, because it seems to play out in sort of bizarre ways if you have to focus it at the level of detail on criminal justice. So and otherwise I'll respond, just leave it to.
Okay, so as it stands now, I have Jenny, Mark, Michael, and Gavin. So we'll go through those four comments and then see where we are in terms of the time.
Thanks. So thanks for both great papers. And maybe John will have a comment about this as well. I want to try to link Colleen's paper back to Avigail's democratic space and try to think through what it would mean for courts to take upon themselves a critical scrutiny into the quality of the democratic space or participation that had generated the decision that is at issue. So I'm actually thinking about this more from an administrative law context, but maybe for the purposes here especially, it would be useful to say, okay, so let's suppose it's a charter right that's at stake in an administrative decision. And now the question that I find inspired by both of these papers is maybe there are contexts, and so one context would be whenever there are charter rights at stake, that the deference that has been increasing, nominally at least, in administrative law towards administrative decision-making should be bracketed by the contexts in which the courts should bring heightened scrutiny to bear on the quality of the process. And that wouldn't be across the board, right? What we would need is an actual jurisprudence, right? We'd need a theory of when it is that we want courts to be asking hard questions about whether the process is all the limitations that Colleen listed, when it's actually facilitating democratic space and when it's not. And so actually the Berger decision is an interesting example. Yeah, because when I heard that we had a discussion of this some years back, and so first we heard a kind of, individual rights perspective, and they didn't, the decision didn't recognize that enough, and then there's no, but the decision, they consulted so widely, this was a model of kind of democratic decision-making, and it's the local people who know how to do this. And then a third comment said, actually, all the people consulted were from the South Asian community. They were not from the Middle Eastern Arabic community, and they have very different norms at stake. And so what was held out as a model of process and, democratic space upon further reflection was very problematic. And so is it the court's job, is one of the things we want the court to do, to interrogate that? When it's being held out to them, well, we had a process, we talked to lots of people. Should they ask, well, which people did you talk to? And were they the relevant people? Now, to ask this is to ask the courts to be stepping in more aggressively for process purposes, at the same time that they're trying to step back on substantive grounds. But maybe we've heard two good arguments about why that's appropriate, but we'll need a much more substantial jurisprudence than we currently have about when they should do that and how they should do that. So.
This comment actually follows directly on what Jenny had to say, although this, at the very end of what she said is something that I think my comment will disagree with. If you look at, this is about Colleen, if you look at a consultation requirement, although this is going to be applicable generally to the kinds of things you're talking about, substantive stuff can come in two ways, I think. One is ex post, which is in some ways what Jenny was talking about, but the question is sort of what triggers your interest in looking into who was consulted? And I think the answer is that that interest is triggered by some sense that the substantive outcome was inappropriate or somehow didn't get it right. Okay, and a sort of a more generalized way of putting it is, suppose you have the defined right is of good faith or meaningful consultation. Well, by looking at outcomes, people will start saying, gee, that outcome could not have resulted from an inquiry, a consultation engaged in good faith. I mean, that's a little strong, but you can see the point. And then there's also the ex-ante design issues. That is, how do you design the consultation? Well, there too, your concern or your thinking about what good design is will be affected by your sense of what the substantive, underlying substantive concerns are. In one area that I know a little about, there's an environmental consultation where the ex-ante design is to have the consultation, roughly speaking, at a public library in the evening. And it turns out, as you might have predicted, that if you hold the consultation in a public library in the evening, you're defining the universe of people who will be consulted. You know, they, like parents who have to take care of the kids at night aren't going to be able to go there. Okay, so you can see. I'll stop.
I got a great deal out of this discussion. I wanted to go back, with John's permission, back to your starting point, your visit this summer home. And I heard you say something, I may have got the facts wrong, and I just wanted to check, that this is a community that was proud of its Aboriginal work for women and a shelter for women, and was looking at having to close it. And one of the things you said in passing was that they were spending 40 grand a month on lawyers defending title in relation to land and resources. And I'm just wondering what that's telling us. I mean, it could be telling us something important about the radical limitations of judicializing and legalizing social claims. I mean, what it's telling us is only the lawyers get rich. And the poorest communities in our country are faced with zero-sum choices between paying the lawyers and keeping the Aboriginal Women's Center open. How did we get here? That sounds like absolutely grotesque result of Section 35 jurisprudence. And I'm just wondering whether, maybe I misheard, maybe I didn't understand what you were saying, but that's what I heard. And if that's what I heard, it's really terrible. And it's terrible for what we're trying to do here.
You did hear it right, and it relates to Sonia's question about resources. The reason they're making the choice to do the title and the resource claims is they hope that one day that will provide a base upon which they can then do the social programming and the other things that are part of that. But you're right. It's all out of balance.
Michael, could you pass the microphone down to Gavin, please? Oh, you've got one right there. Sorry. I've got two now.
Stereo. So it's a question mainly for Colleen. I found your paper very interesting, and it made me think about a conversation we began last evening, and I was formulating a question around it, which is relating, I think, more to the politics of process-based ideas of constitutionalism, or the politics around process against substance. And I wondered if you had thoughts on both who is driving, who is driving these ideas, and who tends to gain or to lose by process-based ideas of constitutionalism. And I'm slightly torn here because I can hear all that both of you say about the pluralistic aspect of the procedural turn and some some individual gains. But I'm slightly concerned at a broader level about whether a procedural turn may actually be anti-pluralist in certain ways. And what I'm wondering here is what is excluded in a process-based constitutionalism. Now, I was talking to Colleen last night about some of the ideas of David Shuley, the late American sociologist. And in his later work, he used process-based ideas very much against a lot of the subaltern voices that we've discussed already, and particularly against theories such as Cohen and Arato, Boaventura de Sousa Santos, to suggest that they are being, I'm paraphrasing here, but potentially totalitarian in their ideas of advancing substantive social justice, because he finds that illegitimate to the extent that some of these ideas are unable to command a sufficient consensus. So if we begin by focusing on process-based constitutionalism, is there a danger that what we do is reify the status quo as the year zero of what can be discussed? In other words, are we, if we take, as I agree with you, to be the case that we can't entirely dissociate substance from process, if we were to emphasize process-based ideas at the present, is the danger that there are a lot of substantive assumptions or substantive decisions already taken which can't then be addressed. And I wondered if you thought that was a danger. Thank you.
Okay, so I think we have a question from Lauren, and then perhaps we'll go back to the panel at that point, and if there's time, we'll let Ben and Jamie ask a question.
So I've really enjoyed the discussion as well. I particularly like the way, Sonia, you were drawing linkages together, because I was also seeing both in each papers and in some of the work I've been trying to do, kind of calls to move beyond some of our comfortable paradigms in each of the papers, but particularly whether it is, and this is one of the eternal questions, viable to distinguish process and substance. And the neat thing of the duty to consult and accommodate, until John made it sound lame by saying it's all about taking away people's rights, was that it was meant to overcome that dichotomy, that it wasn't a procedural remedy in a sense, it was constitutional reconciliation, restorative justice in action, and you show the consultative part by then what you do, and that's why they have to come together. And the problem is, it's like renovating one room in your house and the rest looks terrible. So the rest of procedural justice, if it's not that, looks like it's lame. And so I guess my question in response to why should Aboriginal peoples or Indigenous peoples not get the benefit of this living tree constitutional idea is, why should the rest of our constitutional and administrative law infrastructure not get the benefit of the richness of that idea, apart from the asterisks of taking away people's rights, which as I said, I've got to reflect on, because that does obviously, it's not an asterisk, it's a meaningful context. But you know, is it something that needs to be rooted in a Section 35 context? And I guess that's for each of you to reflect on. And why wouldn't we aspire to that in every procedural or process-based discussion we have?
Okay, why don't we go back to the panel for some reactions to the comments, and I don't know who would like to step up first. It's up to you to decide.
I'm feeling a little overwhelmed. I'm feeling that this paper has a lot of work with all these, because every time someone raises something, I'm thinking, that's, so I first of all, thank you for the comments in terms of deepening the discussion and helping me to sort out how to further pursue some of these ideas. And first, in terms of Jenny's comments about a democratic space, picking up on Abigail's, I think that's right. And although I see that in partly, potentially in tension with Gavin's point, in that if we begin to, on the one hand, you want to create a space which to allow for self-governance and self-determination, and for people who have to set up the processes for self-governance. On the other hand, you might want to set out more clearly a theory of procedure, of what's fair, who's included, is it equitable, what kinds of power, being attentive to power imbalances or privilege imbalances. So I wasn't, because Gavin, I'm not sure I totally understood your point, but if you were suggesting that there might be a risk that a procedural turn would undermine legal pluralism, which does allow for significant differences in terms of how people consider. And that goes back to that old problem of, to what extent do we allow self-governing communities to make choices that may or may not, we being like a dominant Canadian legal community, agree with. So, Mark's point about the links between substance and process, and the ex post and the ex ante ex post evaluation and ex ante design issues, again, I think they're really interesting, and I think I'll take them into account. And again, I think it underpins the difficulty of delineating process and substance in any rigid way. So, so I think I'll just stop there, and thank you. Lauren, I take your comment as comment, so I'm going to just continue thinking about these issues. So.
Yeah, so I think it'd be wonderful to see Indigenous peoples participate in the nourishment and growth of Canada's living tree, such that some of the values and understandings that Indigenous peoples might bring to that, as imperfect as they are, still would make a contribution and enrich the things that you talk about and what you're dealing with in terms of building democratic spaces for this kind of engagement. But there's these structural obstacles that are skewing the way we attend to this in such perverse ways. But I can understand at one level why the council will make that decision, even though I wouldn't make that same decision, because they want to correct the underlying ground upon which then all subsequent decisions are made. And until that's done, it's hard to get on with the process of dealing with all of these many substantial crises that are also a part of it. So that's why I say dealing with violence against women isn't just interpersonal, it's structural. And the structural components aren't just male domination. It's male domination as it relates to colonialism, as it relates to failure to create a space where Indigenous peoples can participate in the nourishment of this Constitution, be part of the constitutional, be an agent in the development and growth of our country. So that's why I'm a little bit hesitant, although I take the point, why don't you just make an argument that Indigenous peoples exercise criminal jurisdiction power before non-Aboriginal peoples came, because then you can say that was integral to their distinctive culture, they can do it today. Because I think the historical reference is part of the structural problem here, putting in the past the opportunities for people to work on what Lauren's referring to, and it's not just about the past. It's rooted in the past and it grows from the past, but it can't be limited by that moment either. And so I think that there's a lot that can actually be drawn together in the two pieces.
Yeah, really briefly, I feel a little bit like reflecting back Abigail's comment earlier. Maybe I shouldn't say anything because I'm going to end up saying something I actually disagree with. But I do want to just push back a little bit gently on something I think I'm hearing, and I could be wrong about this. My inclination would be to draw a line between what's going on in duty to consult and what's going on in some of these other areas, what's going on in duty to consult under Section 35. Because some of these rules that we're talking about, in particular, I'm thinking about Jenny's comment about the way that the consultation is happening. So I think that Section 35, duty to consult, is about government-to-government consultation. The other forms of dialogic participation that Colleen's talking about may very well be different. And I think that they raise very different boundaries for how far the court should be going into looking at what's actually happening in the internal consultation. I think what the court should be doing in duty to consult is considering very carefully the power imbalance between the parties. I think given the way that Section 35 has been interpreted, the idea that the court's going to investigate the internal politics of the community and then make a decision about whether or not that's just is much more fraught in the Section 35 context than it is in some of the other contexts. So that I would just want to suggest that maybe we need to draw a line there.
Okay. So, but can I just clarify? So you would invite the courts to be to bring critical scrutiny to bear on the power imbalances in the government-to-government negotiation, but not to the internal decision-making of Aboriginal councils, which are then brought to this government-to-government. Is that what you're saying?
Yeah, my sense is that the dialogic consultation or dialogic participation in some of the other things is between citizens and the state, and that's a
Right.
particular thing. That's
Right.
not what's happening in Section
Right.
35, in my view, and to
Right.
interpret it that way, I think creates a
Right, I
particular kind of
understand.
problem.
Yeah.
Particularly if we take, like I was resisting the suggestion that you can go from the result of the consultation to a belief about whether the consultation was properly done. And I was thinking, yeah, so sometimes maybe we can do that, but other times I think we're unable to do that because we've acknowledged that the community has specialized knowledge that we don't have. So it's unclear how we could determine that the outcome was a problem or not a problem from simply looking at the outcome, that the process was a problem from looking at the outcome. I'm not sure how far we can take that point.
Okay, thank you. I think I'll claim the moderator's prerogative, just to add a couple of very quick comments, and then we're going to hear from Lorne, and there's one other little piece of business we'd like to do before break. But as authors of the papers know, Ben and I will be sending written comments, so we've pulled back at the open sessions here. But I just wanted to say, John, I wondered whether there's any possibility of pairing the concept of a residual power with the living tree concept to sort of bring some traction to the past and the present. I don't know, maybe that's foreclosed in the jurisprudence by the way, by the manner of the discussion, but that's something that occurred to me. I also wondered how you make, and this is a point about constitutional interpretation, how you make an argument for jurisdiction over domestic violence, which doesn't essentially become an argument or a claim for complete jurisdiction and complete sovereignty over all issues. So I wondered about that. And Colleen, I just wanted to raise the possibility that maybe not all process claims are equal. And I'll just sort of, and others have sort of raised the question of what the impetus is for the court going to a process rationale or a process methodology. And I guess I would just float the suggestion that sometimes it's done for the court's convenience and purely to advance opportunistic decisions. And I give the two examples that bother me the most of the ones you have pointed out are the secession reference, which to me is an instance of institutional vanity. And the other one is the BC Health Services, which to my mind took a substantive guarantee and downgraded it to a procedural guarantee so that what we have now is a guarantee, Section 2D, that has no substantive content and procedural content that's unworkable. So anyway, I'll stop there because I see that our members of the Osgoode Research Office and Law Journal have joined us. And one of the things we've wanted very much to remember to do throughout the day is to pay our debt of gratitude to those who have given us enormous support in putting this project together. And so joining us at the back of the room are two members of Osgoode's Research Office, Laurie Cormack and Jody Ann Rowe Butler. Ben and I would not have been able to get this event up and running without the enormous assistance that both of them have provided us over the summer, and we just publicly want to acknowledge their efforts. But I wasn't quite finished because with Laurie and Jody Ann is Stefania Piacenti Battisti, who is the coordinator of the Osgoode Hall Law Journal, and we have also benefited enormously from her assistance in putting the event together. So we asked them to join us so that they could be publicly thanked. And so now having done that, our final piece of business before the break is just a word from our dean.
Yeah, no, and mindful that I stand between you and a break, I had just asked Ben and Jamie at some point today for the chance to do two very pleasurable things from my point of view. One is, again, to acknowledge the pride Osgoode takes in welcoming all of you here today, especially for this kind of day, and especially to put the Osgoode Hall Law Journal front and center, which will ultimately convey the fruits of the discussion today, and of course the students, staff, and faculty who make this possible. And I'm glad to see Jamie has already done the word of thanks to the research office. It's a chance for us also, of course, to welcome you to the building, and I've seen everyone distributing themselves around the hall outside and throughout some of the new spaces that we're proud of. I couldn't help drifting my eye from the compelling speakers to the open sockets above. That suggests there's a work in progress here as a metaphor for the Charter itself. And this room will be finished long before the constitutional project. But I hope the kind of discussion we have seen, especially this session from a personal point of view, has been very engaging. All the sessions have advanced our thinking, but I think also reminded us just how incredibly young and fluid our constitutional traditions are as works in progress. And then finally, since everyone has been acknowledging Ben and Jamie along the way, it gives me a chance to formally ask you to do that with me for all of their efforts in putting this together today. So to Ben and Jamie, thank you for making today possible.